It's easy to think of things like the U.S. Constitution or the Supreme Court as these static, almost dusty entities governed by rigid rules and perhaps less than lively people in robes.
That image is common, yeah, but as the history you've shared with us makes wonderfully clear, the reality is far more dynamic and, frankly, much more human.
Right.
The justices are individuals shaped by their times and experiences, and the Constitution itself is less of a fixed rule book and more of a framework whose meaning has been constantly shaped and reshaped by the people who interpret it.
Exactly. Diving into centuries of history, pivotal cases, and the lives of the justices can feel like navigating a dense forest of information. It's overwhelming.
Mm.
But a goal in this deep dive is to be your guides, sort of cutting through the complexity to find the most essential knowledge and the surprising insights that make this story come alive.
We're going to unpack the source material you've provided, a history that explores key figures, landmark cases, and the crucial debates from the nation's beginnings right through the late 20th century. Our mission is to explore the history of the Supreme Court and how its cases and the people who served on it have profoundly shaped the Constitution, using this rich material as our map.
Okay, let's jump right in and lay the foundation. To understand the Constitution, we have to look even further back than the Constitutional Convention, right? It's the very roots of American law in the colonies.
That's right. The source highlights early legal codes, like the Body of Liberties, adopted by the Massachusetts Bay Colony in 1641. And what's fascinating is how these Puritan codes, driven by religious and moral concerns, contain provisions that really foreshadowed later constitutional protections.
Like due process and even early inklings of equal protection. Is that what you mean?
Precisely. Though it's a crucial caveat that these rights were largely confined to free men, definitely not universally applied. They also drew heavily from the Mosaic Code, using severe penalties, even death, as a means of social control and enforcing outward conformity, despite evidence that nonconformity was perhaps more common than they like to admit.
It paints a picture of a society wrestling with how to structure law and order long before the national conversation began. Which brings us to 1787 and the Constitutional Convention in Philadelphia. The source gives us a remarkable window into those debates, largely thanks to one man,
James Madison. He undertook the incredible task of meticulously recording the proceedings, sitting in front of the presiding member to try and capture every argument, every subtle shift. Just amazing dedication.
And his motivation wasn't just academic, was it? He saw himself contributing to the history of a constitution on which would be staked the happiness of a people and possibly the cause of liberty throughout the world. That's an immense awareness of the stakes involved.
That sense of gravity is palpable in his notes, especially when you look at the debates. One major tension was overrepresentation and the very idea of popular democracy. You had figures like Elbridge Gerry and Roger Sherman expressing deep suspicion of the leveling spirit, worried that the populace could be misled by false reports circulated by designing men,
A real fear of direct democracy.
Yeah. Contrast that with George Mason of Virginia, who argued passionately for popular election of the larger branch, calling it the grand depository of the democratic principle. And Mason, speaking as a fellow property owner, offered a sharp reminder to Gerry and others. He suggested that their selfish motive of protecting property would be best served by protecting no less carefully for the rights and happiness of the lowest than of the highest orders of citizens.
That's striking.
It's a striking point, particularly coming from a Virginia planter.
It is, and the source notes the irony. New Englanders, known for town meetings, were often more wary of popular democracy than some of the Virginia aristocracy. And Mason himself, a slave owner, was a vocal opponent of the infernal traffic in slaves. It shows the complexities and contradictions within the framers themselves. Just incredible.
Another core conflict was the balance between national power and state sovereignty. Madison initially pushed for a strict enumeration of federal powers, but found it practically impossible, ultimately deciding he would shrink from nothing which should be found essential to creating a strong, functional national government.
And in a twist the source finds fascinating, William Paterson, the champion of state control with the New Jersey Plan, was actually the first delegate to propose making the Constitution and federal laws the supreme law of the land.
An advocate for the states planting the seed for federal supremacy, it highlights how intertwined and complex their ideas were. It's easy to miss that. And then, of course, the compromises forced by slavery were profoundly difficult. Pierce Butler was direct, stating the security the southern states want is that their Negroes may not be taken from them. Just blunt.
While James Wilson countered that All men wherever placed have equal rights, and property wasn't the government's sole concern. The debate over counting slaves for representation led to the Three-Fifths motion and the ultimate Great Compromise, a really ugly part of the process.
Yeah. When the drafting finished, not everyone was satisfied. Mason was disappointed by the failure of his motion requiring two-thirds vote for navigation acts.
And Edmund Randolph, who had presented Madison's plan, ended up denouncing the finished document, seeing dangerous power given by the Constitution to Congress. He really changed his tune.
Later interpretations, like Charles Beard's 1913 economic analysis, argued the framers were primarily driven by economic self-interest. Beard calculated their wealth in public securities, land, businesses, and slaves, placing this argument firmly within the progressive era context of muckrakers exposing perceived corruption. It was quite influential for a time.
After the convention, the fight moved to ratification in the states. Debates were heated. In Massachusetts, the Agrippa essays argued powerfully against the lack of a Bill of Rights.
Federalists responded that it was unnecessary since the federal government only had enumerated powers, but Anti-Federalists saw the broad potential in the necessary and proper clause. They were worried.
In New York, Anti-Federalists like John Lansing pushed for specific amendments, including a due process proposal that, with minor changes, became the basis for the Fifth Amendment in the Bill of Rights.
That promise of amendments was crucial in securing ratification in states like New York and North Carolina. Rhode Island was the last to join, grudgingly, by the narrowest of votes.
So even the Constitution's birth was a hard-fought compromise. It wasn't inevitable.
Not at all.
Okay, once the Constitution was ratified and the new government was established, it was time to set up the Supreme Court.
And the source notes the stark contrast between the modest beginnings of the U.S. Supreme Court and the prominent law lords of England, like Sir Edward Coke, Lord Edward Mansfield. Few Americans even knew who the first justices were. They weren't exactly household names.
It sounds like Washington's early appointments were less than stellar. The source calls them a thoroughly undistinguished lot. Is that fair?
That might be an understatement, honestly. Imagine
Yeah.
a justice in debtor's prison, one who resigned after 5 days, one who never even showed up for a session, one impeached for political bias, one who became insane, another senile. It's kind of unbelievable. Chief Justice John Jay was simultaneously campaigning for New York governor and conducting diplomatic missions. John Rutledge was rejected by the Senate after a controversial reappointment. Even James Wilson, so key in framing the Constitution, is described as having significant flaws like vanity and ambition, using shameless flattery to pursue the Chief Justice role.
That's quite a collection of characters, and they had the burden of circuit riding, traveling constantly in often difficult conditions, roads, taverns chiefly, to sit with district judges. That must have been brutal.
Oh, yeah. Justice Thomas Johnson complained he cannot resolve to spend 6 months from my family on roads, and Chief Justice Jay himself said, "It takes me from my family half the year." This was not a desirable job for many prominent lawyers. Not at all.
It's hard to imagine that this shaky start would lead to the judicial leviathan the court would become. That transformation is credited to John Marshall.
Yes, his appointment was pivotal, absolutely critical. The source attributes his success in turning the court into such a powerful institution far from what Hamilton called the least dangerous branch to 4 factors: his iron will and fierce determination, his remarkable good health and longevity on the bench, and his sheer intellectual ability to build his reputation as the greatest Chief Justice.
And his most famous moment, the foundation of the court's power, is Marbury v. Madison, right?
An odd beginning, as the source puts it, linked to Marshall's own oversight as Secretary of State, leaving those undelivered commissions. You know, a clerical error, basically. Thomas Jefferson saw the judiciary as a stronghold for Federalists and was spoiling for a fight. He really wanted to take them on.
Marshall's genius was navigating that fight, instead of just saying the court couldn't hear Marbury's case because the law giving it power was unconstitutional.
Right, which he could have done easily.
He used it as an opportunity to assert the power of judicial review.
Yes, exactly. He lectured Congress, declared Section 13 of the Judiciary Act unconstitutional, and used that famous rhetorical question. Could a legislative act contrary to the Constitution bind the courts? To say yes, he argued, would be an absurdity too gross to be insisted on. He claimed for the court the ultimate authority to interpret the Constitution. It was a masterful move.
Even in these early years, there were clashes and attempts to check the court's power, including early impeachments.
We saw Judge John Pickering impeached and convicted, though he was likely insane. More politically charged was the impeachment of Justice Samuel Chase, a Federalist accused of partisan bias, particularly for attacking the repeal of the Judiciary Act and calling Jeffersonianism mobocracy. Jefferson himself was criticized for interfering in that case. Got pretty messy.
During the Marshall Court era, the justices lived together in a Washington boarding house, which the source notes created a specific dynamic, like a fraternity almost.
Sort of, yeah. It could give lawyers who were part of that social circle, like Joseph Story, an advantage over opponents. The source mentions Luther Martin, a legendary but erratic lawyer, reportedly appearing drunk in court on one occasion. Imagine that.
Wow. Marshall's court didn't just establish judicial review, it defined the fundamental balance of power in the young republic. Cases like Fletcher v. Peck were crucial.
This involved the notorious Yazoo land fraud, a clearly corrupt deal. Yet Marshall, writing for the court, deliberately looked past the tawdry history of bribery. He focused on the principle of the sanctity of contract. He ruled that a state legislature was fully competent to convey land and upholding the contract between Fletcher and Peck, even though everyone knew about the fraud. He prioritized legal principle over the messy, corrupt facts of the case. It was quite something.
Then came McCulloch v. Maryland, perhaps the most significant case for federal power. Maryland was trying to tax the national bank.
Right. Luther Martin, arguing for Maryland, claimed Congress only had express powers listed in the Constitution. Daniel Webster and William Pinckney, arguing for the bank, relied on implied powers. Big showdown.
Marshall, in his brilliant opinion, made a tactical concession, admitting the bank wasn't explicitly listed, but then he used the necessary and proper clause to deduce that power from other enumerated powers, like taxing, borrowing, and regulating commerce.
And the source notes that Marshall rarely stated anything original in his opinions. His power came from selecting the most compelling arguments and putting his judicial imprimatur on them, making them the law of the land. McCulloch is a prime example, taking the idea of implied powers and making it a cornerstone of federal authority. Just masterful.
But Marshall wasn't always on the side of expanding federal power, especially when it came to individual rights or states' ability to manage their own affairs in certain areas. He wasn't always consistent, maybe.
Well, that's clear in Ogden v. Saunders, which dealt with state bankruptcy laws. Daniel Webster argued with a fanciful legal doctrine that states couldn't pass such laws, claiming contracts were governed by a universal law. Marshall and 3 other justices agreed, showing their suspicion of laws aimed at debtor relief.
But the majority, led by Justice William Johnson, disagreed. Johnson saw states as having a concurrent power and argued they were more than just counties, stating that rights must be held and enjoyed in subserviency to the good of the whole. A different philosophy there.
Yeah, and the original intent of the contract clause, as interpreted by James Wilson, was only to prohibit states from interfering retrospectively with contracts. But Marshall dissented passionately, claiming the majority decision would make the clause inanimate, inoperative, and unmeaning for the good and the wise, those who upheld their debts. He felt strongly about that.
And his approach to individual rights against state power is starkly shown in Barron v. Baltimore. This one's really key.
This 1833 case established that the Bill of Rights is not applicable to the legislation of the states. It seems almost incredible now, but at the time, the source notes this decision attracted little notice.
While Marshall is lauded as a nationalist, the source offers a crucial perspective here. He had little respect for the rights of the people against the government, state or federal, and found little difficulty in rejecting the argument that the Bill of Rights limited state power, despite his usual broad interpretations of federal authority. It's a contradiction, almost.
It's a really important point to understand about his jurisprudence. After Marshall's long tenure, the court began to shift, reflecting the growing sectional divide over slavery. Andrew Jackson's appointments included states' rights advocates like Roger Taney, who would become Chief Justice, and others like McLean and the ineffective or mentally ill Baldwin, a different kind of court emerging.
This shift is seen in cases like Charles River Bridge v. Warren Bridge.
Yeah, Chief Justice Taney's decision favored economic competition, arguing against implied monopoly rights. This contrasted sharply with Justice Story's dissent, which relied on interpreting implied terms from common law principles, which Story called as old as the very rudiments of the common law. The source suggests this reliance on ancient doctrines perhaps unwittingly exposed their crumbling foundation in a changing economy. Interesting take.
Meanwhile, the national tension over slavery was reaching a boiling point. fueled by westward expansion and the conflict over whether Congress could prohibit slavery in new territories.
The Missouri Compromise of 1820 was a fragile truce. Militant abolitionists, using newspapers like the Emancipator and the Underground Railroad, clashed with Southern defenders like John C. Calhoun, who argued slavery was a positive good.
It was getting really ugly.
Oh yeah, laws were passed making advocacy of abolition a felony, and vigilante groups proliferated.
Dramatic events punctuated this period, like the Amistad case in 1841, recounting the slave revolt led by Cinct and the legal battle that followed after they landed in the U.S. Such a powerful story.
All of this history, this escalating conflict, culminates in the shadow cast by Dred Scott v. Sanford. This is the big one.
The case itself revolved around Dred Scott, an enslaved man who had lived in free territory. The question was whether this residence removed the chains of slavery based on the once free, always free doctrine.
Kentucky judges had dismissed this doctrine in the Strader case, and Chief Justice Taney seemed determined to use Strader to signal to state judges that it no longer applied. The Missouri judges followed his lead in Scott's case.
Right.
It's worth noting that Dred Scott's lawyer, Montgomery Blair, a close friend of Abraham Lincoln, offered his services free of charge, and the defendant's name was famously misspelled Sanford by a clerk. Little details that stick.
Taney's opinion in Dred Scott is one of the most infamous in American history. How did he handle the Declaration of Independence's assertion that all men are created equal? That seems like a major hurdle.
It was a huge challenge for him. Taney concluded, in words the source says are too clear for dispute, that the enslaved African race were not intended to be included as citizens, viewing them except as property. Stark. The source points out how thin and tendentious his historical evidence was, highlighting that free blacks could vote and hold rights in many states in 1776. He ignored that inconvenient fact.
And then came his truly audacious and totally false conclusion that all blacks, free or slave, were identified in the public mind with the race and regarded as a part of the slave population.
This effectively stripped black people of status as persons with constitutional rights in the eyes of the court. Incredibly, only 2 justices dissented on this central tragic question.
Just 2.
The decision was a devastating blow and a direct catalyst for the Civil War. No question about it.
After the war, Abraham Lincoln appointed Salmon P. Chase as Chief Justice. Chase was a political rival, backed by radical Republicans, chosen despite Lincoln's reservations for his political stature and personal magnetism to try and restore the court's prestige after Taney. A political calculation.
Absolutely. The tension continued during Reconstruction. President Andrew Johnson clashed violently with Congress, vetoing the Civil Rights Act of 1866. He denounced it as a stride towards centralization and, displaying blatant racism, claimed it operated, quote, in favor of the colored and against the white race.
That veto override pushed radical Republicans to pursue constitutional amendments, like the 14th, specifically to protect the rights of freedmen from state interference. They needed something more permanent.
Yeah. Military Reconstruction did see high black voter turnout and the election of black delegates, legislators, and congressmen. However, the source notes a decided shortfall in holding higher office due to a mix of factors: deference, lack of prior experience or education, and the constant, terrifying threat of violence from groups like the Ku Klux Klan. The progress was real but fragile.
And tragically, the Supreme Court itself began limiting the scope of Reconstruction rights almost immediately.
In the slaughterhouse cases in 1873, Justice Miller's opinion included paragraphs completely irrelevant to the Louisiana law being challenged, warning Congress to stay away from the business of civil rights enforcement, essentially trying to constrain the 14th Amendment's Section V power.
Wow.
Notably, even the dissenters didn't object to this warning. It was a signal.
This undermining continued in United States v. Cruikshank, which arose from the horrific Colfax Massacre.
Chief Justice Waite's opinion found technical defects in the indictment under the Ku Klux Klan Act, ruling that federal law couldn't protect the right to vote because it wasn't a necessary attribute of national citizenship, dancing around the 15th Amendment. But the most damning point, highlighted by the source, is Waite's claim that the indictment didn't allege the wrong was on account of race or color, directly ignoring the obvious fact that the victims were described as of African descent.
Just ignoring reality.
It was a willful blindness to the reality of racial terror, just gutting the enforcement acts.
As the nation moved into the Gilded Age, national politics shifted. The issue of race faded from the federal stage, except in the South, and presidential elections turned heavily on economic issues.
This era saw Supreme Court appointments increasingly favoring men whose legal experience and judicial philosophy favored the interests of business and industry. Appointments by presidents like Cleveland and Harrison, such as Lamar, Howell Jackson, and George Shiras, who the source calls joining the laissez-faire bandwagon, often had backgrounds representing corporate interests. You saw a definite trend.
This environment set the stage for the rise of legally enforced racial segregation, the Jim Crow era, and the legal challenges that followed in the 1890s.
Leading infamously to Plessy v. Ferguson in 1896. Homer Plessy, who was 7/8 white but considered black under Louisiana law, deliberately entered a white railroad car to challenge the 1890 law requiring equal but separate facilities.
Yeah.
The law was vague on defining race, leaving conductors to make the assignments. Just arbitrary power.
Public opinion had become even more hostile toward blacks, with more Jim Crow laws and efforts to purge black voters from the rolls. It was a dark time.
Albion Torgey, Plessy's lawyer, submitted a powerful brief urging the justices to imagine waking up with a black skin and being ordered into a Jim Crow car. But Justice Brown's majority opinion upheld the law, citing the earlier civil rights cases, though the source notes this citation actually undermined his argument and lacked precedent. It wasn't strong reasoning.
The most enduring part of Plessy is Justice John Marshall Harlan's dissent, isn't it?
Absolutely. His dissent contained the famous line, often summarized as, "Our Constitution is colorblind." The source is careful to provide context. Harlan was not arguing for social equality and was a man of his time, son of slave owners who believed in the superior status of white people. But crucially, he was not a racist like Chief Justice Taney, and correctly predicted that the decision would, in time, prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. He saw where it would lead.
And yet, the source notes, the decision received very little attention when it was handed down, buried on page 3 of the New York Times, overshadowed by other cases. It wasn't immediately seen as the monumental endorsement of segregation it became. People didn't grasp its significance right away.
Exactly. The late 19th and early 20th centuries were also defined by intense industrialization and the struggle over economic regulation, leading to the era often called the Lochner era.
The intellectual backdrop was dominated by the popularity of Herbert Spencer and social Darwinism. His publisher sold hundreds of thousands of copies, and ideas promoting individualism and denouncing government intervention to help working people were spread widely through publications like Popular Science Monthly. It was the dominant thinking.
This coincided with brutal labor disputes, like the Pullman strike in 1894. Attorney General Olney used the Sherman Antitrust Act, originally aimed at business monopolies, to get a sweeping injunction that even banned persuasion by strikers.
Using an anti-monopoly law against labor.
Exactly. President Cleveland sent federal troops, leading to violence, deaths, and arrests, including union leader Eugene Debs for contempt. The strike was broken, the union crushed, and workers blacklisted. It was harsh.
The source paints a grim picture of worker conditions: urban sweatshops, widespread child labor, families following crops, thousands of deaths and injuries annually by 1914, with employers bearing none of the cost. This context fueled the rise of more radical unions like the IWW and ILGW. Something had to give.
Which brings us to the defining case of the era, Lochner v. New York in 1905.
Justice Peckham's majority opinion struck down a New York law limiting bakers' hours to 10 a day, 60 a week. His stance was rigid. The law necessarily interferes with the right of contract, which he saw as protected by the 14th Amendment's Liberty Clause. Freedom of contract above all else.
He dismissed the prior case, Holden v. Hardy, which upheld laws limiting miners' hours due to dangerous conditions, without clearly explaining why the distinction mattered, leaving it for conjecture. His view was essentially that any regulation of labor hours infringed on the freedom of both employer and employee to contract.
Justice Holmes famously dissented, arguing the court shouldn't strike down laws simply because they reflect economic views the justices disagreed with. He said, "It is not the function of the court to hold congressional acts invalid simply because they are passed to carry out economic views which the court believes to be unwise or unsound." A classic dissent.
Despite Lochner, lawmakers continued to pass protective legislation, leading to cases like Muller v. Oregon in 1908, which upheld a law limiting women's laundry hours. Louis Brandeis's brief was groundbreaking, using extensive sociological data to show the detrimental effects of long hours on women's health. The Brandeis Brief.
Justice Brewer's opinion upheld the law based on the special physical structure and maternal function of women, but notably, he did not overrule Lochner. It created a strange exception rather than a change in fundamental doctrine, kind of a workaround.
Exactly. Later appointments, particularly under President Taft, solidified the court's conservative, pro-business bent. He elevated Edward D. White, who invented the rule of reason, which Holmes later lamented, and appointed George Sutherland, one of the future Four Horsemen, who would fiercely resist regulation. Stacking the deck, really.
This conservative trend culminated in Adkins v. Children's Hospital in 1923.
Justice Sutherland, speaking in the laissez-faire words of the Lochner era, struck down a minimum wage law for women in the District of Columbia. He argued that even the economic hardship following World War I didn't justify abridging the freedom of contract, just doubling down.
Chief Justice Taft dissented, again echoing Holmes's call for judicial restraint regarding economic legislation. And Justice Holmes himself wrote a dissent filled with thinly veiled scorn, tracing the interpretation of liberty from an unpretentious assertion to this rigid liberty of contract.
Holmes pointed out that contract isn't mentioned in the Constitution, and that all law restricts actions, including the ability to contract freely. The source notes that by this time, only Holmes and McKenna remained from the Mueller Court, and the Four Horsemen bloc, Van Deventer, McReynolds, Butler, and Sutherland, voted against the law, signaling their determined resistance to future regulatory efforts, particularly those of the New Deal. The battle lines were drawn.
Moving into the early 20th century, the court also grappled with the limits of speech and dissent, especially against the backdrop of World War I and the subsequent Red Scare.
The Espionage Act of 1917 was incredibly broad, aimed not just at spying, but punishing anyone who would willfully cause or attempt to cause insubordination or obstruct the recruiting. The argument was that even criticism could induce draft resistance, which was a real concern given widespread resistance. It was a tense time.
This led to key free speech cases, starting with Schenck v. United States in 1919.
Charles Schenck distributed leaflets urging resistance to the draft. Justice Holmes introduced the famous clear and present danger test, defining it as whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent.
He used the vivid analogy of falsely shouting fire in a theater. While he adapted terms from a lower court judge, Borkren, he applied them differently, finding Schenck's actions met the test. It sounds reasonable, but...
Then came Debs v. United States, also in 1919, involving socialist leader Eugene Debs' speech, criticizing the war and praising convicted comrades. Justice Holmes seemed personally offended by Debs' remarks.
Evidence of Debs' sympathy for those resisting the draft was used to infer his intent, even though he hadn't directly incited resistance. Crucially, Holmes didn't explicitly use the clear and present danger test here, finding it enough that the natural tendency of the speech was to obstruct the recruiting service.
The source notes that this led to the more restrictive bad tendency test, which simply asked if the speech tended to produce a bad result, a much lower bar and more dangerous to dissenters, a significant weakening of the standard.
But then something changed in Holmes's thinking. He didn't stick with that.
No. The source highlights that in the months after Schenck and Debs, Holmes shifted his perspective. He listened to critics like Judge Learned Hand, who argued for a higher standard focusing on direct incitement. He evolved.
This intellectual shift culminated in Holmes's famous dissent in Abrams v. United States later the same year. The case involved Russian anarchists distributing pamphlets protesting U.S. intervention in Russia.
Holmes, joined by Brandeis, argued passionately for the marketplace of ideas, the principle that truth is best discovered through the free exchange of ideas, even those we hate. He famously stated that every idea is an incitement. Powerful stuff.
Powerful, yeah.
The majority upheld the convictions, sending the anarchists to prison.
This all took place during the first Red Scare, fueled by figures like J. Edgar Hoover, creating lists of suspected radicals and the Palmer raids, arresting hundreds, culminating in the deportation of Russian aliens on the Red Ark, a period of real fear and repression.
The Red Scare also led to state laws criminalizing certain forms of speech, like New York's criminal anarchy law challenged in Gitlow v. New York in 1925. Benjamin Gitlow was arrested for distributing a left-wing manifesto.
And California's similar law challenged in Whitney v. California in 1927. Initial convictions of these cases were upheld, so the bad tendency test held for a while.
For a bit, yes. However, as the hysteria subsided, governors pardoned figures like Gitlow and Whitney. And by the 1930s, the court began reversing convictions under similar laws, such as in DeYoung v. Oregon in 1937, although it avoided directly overruling the earlier Whitney decision at the time. It shows how the court's interpretation of speech rights evolved, though sometimes slowly, influenced by changing societal moods.
Which brings us to the dramatic tension between Franklin D. Roosevelt's New Deal and the conservative Supreme Court in the 1930s. The Four Horsemen versus FDR.
The court became a major obstacle, striking down key New Deal programs. Roosevelt's frustration was palpable, captured in his horse and buggy comment in 1935. Press speculation about his plans for the court grew, fueled by columns blasting the court after decisions like Moorhead. People wondered what he'd do.
Some of the early New Deal casualties included Panama Refining v. Ryan in 1935, where the hot oil law was struck down based on the non-delegation doctrine. Chief Justice Hughes found Congress had set no policy and no criterion for the executive to follow. Too much power given away.
That was the argument. And the infamous sick chicken case, Schechter Poultry Corp v. United States, also in 1935. Chief Justice Hughes, writing for a unanimous court, ruled the Schechters weren't engaged in interstate commerce because the poultry had come to a permanent rest, and therefore Congress lacked authority to regulate them under the Commerce Clause. A very narrow reading.
Then came Moorhead v. New York ex rel. Tupalo in 1936, striking down a minimum wage law for women. Justice Butler's majority opinion used the familiar laissez-faire words of the Lochner era, arguing the economic emergency of the Depression didn't justify infringing on freedom of contract, still clinging to Lochner.
Meanwhile, labor relations were incredibly contentious. Roosevelt's intervention in an auto strike forced unions to include company unions, rendering the National Labor Board impotent and leading to a wave of strikes described as virtual class warfare. The Wagner Act created the National Labor Relations Board, but it initially faced resistance even from lawyers within the Justice Department who didn't support its majority rule principle. Internal fights, too.
But then came the pivot, the Constitutional Revolution of 1937, the switch in time that saved 9.
Right. The turning point came with cases upholding New Deal legislation, perhaps most vividly captured by Jones and Laughlin Steel Corps, the NLRB, one of the Wagner Act decisions. The source quotes Labor Board lawyer Tom Emerson, describing Chief Justice Hughes reading the majority opinion upholding the act as an amazing performance, thundering with his beard wagging, making it sound like the law had always been this way, delivered with an air of absolute confidence, just projecting total certainty after the switch.
This marked the court's shift. The source notes that the newly aligned majority, the New Deal justices, began shifting the agenda from property rights, which had dominated the Lochner era, to human rights. A key figure in this shift was Justice Harlan Fiske Stone.
Stone, described as having a Yankee conscience, affronted by intolerance and bigotry, would become instrumental in providing constitutional protection for minorities. He saw a new role for the court.
He did this notably through footnote 4 in the otherwise unremarkable case, United States v. Caroline Products in 1938. That footnote had huge implications, didn't it?
Oh, absolutely. This short footnote was hugely significant. Stone suggested that while courts should generally defer to legislatures, a searching judicial inquiry, a higher level of scrutiny might be necessary where legislation restricts political processes or shows prejudice against discrete and insular minorities who might struggle to protect themselves through the political system.
Right.
It was a signal that the court would open courtroom doors to politically helpless minorities, a roadmap for future litigation.
This principle was quickly tested, particularly with the Jehovah's Witnesses flag salute cases. Witnesses refused to salute the flag based on their religious beliefs, a stance made more poignant by the fact that the Nazi regime in Germany also banned witnesses and forced flag salutes. The parallels were stark.
In the first case, Minersville School District D. Gobitis in 1940, the court upheld the expulsion of Lillian and William Gobitis for refusing to salute the flag. Justice Frankfurter wrote the majority opinion, arguing for deference to state officials to promote national unity.
But Stone wrote a powerful dissent, citing footnote 4 and arguing the decision was a surrender of the constitutional protection of the liberty of small minorities to the popular will, standing alone.
The story doesn't end there, though. Schools continued enforcing the regulations and expelling witnesses. In 1942, in Jones v. Opelika, a licensing case, 3 justices who had joined Frankfurter and Gobitis took the unusual step of writing a dissent to repent their prior votes, calling it a logical extension of the principles of Gobitis and stating they now believe that it also was wrongly decided.
They publicly changed their minds. That's rare.
Incredibly rare. The source notes this remarkable change's heart was influenced by news reports and photographs of handcuffed witnesses and burned churches that seared their consciences. There's the famous anecdote about Frankfurter scornfully asking Justice Douglas if Justice Black, one of the repentant justices, had been reading the Constitution. Douglas's reply, "No, but he has read the papers."
That's great.
It underscores how real-world consequences influence the justices.
This led directly to West Virginia State Board of Education v. Barnett in 1943, where the court, led by Justice Jackson's eloquent opinion, overruled Gobitis, affirming that compelling a flag salute violated the First Amendment, a major victory for individual conscience.
Another tragic episode the source covers is the Japanese-American internment during World War II. Japanese Americans were viewed with suspicion solely on the basis of their shared race and ancestry, leading to mass forced removal and imprisonment based on nothing but race.
The source shares the stories of individuals like Gordon Hirabayashi, a pacifist who questioned why he, an American citizen, had to obey a discriminatory curfew. Min Yasui, who deliberately sought arrest to challenge the law, but was initially ignored, later spending 9 months in solitary confinement, and Fred Korematsu, who tried to evade evacuation by changing his name. Brave individuals.
These became test cases, reaching the Supreme Court. Hirabayashi, Yasui, Korematsu. But what's particularly damning, according to the source, is the government misconduct involved.
What kind of misconduct?
The government suppressed findings of Japanese-American loyalty and altered wording in their final report justifying the internment. Solicitor General Charles Fahey vouched for this altered report, and Justice Hugo Black then cited it in his Korematsu opinion as sufficient evidence of disloyalty to justify the mass evacuation based on ancestry alone. Basically, the court relied on falsified evidence.
That's shocking. The conviction stood at the time. But decades later, in the 1980s, historian Charles Irons tracked down the 3 men and showed them the evidence of government misconduct.
This led to a team of committed young lawyers, many children of internment survivors, pursuing coram nobis challenges, essentially asking the court to correct a fundamental error in the original proceeding.
Right.
Using government files, they successfully challenged the convictions decades later, urging judges to carefully weigh the complete record of governmental abuses. Just as finally, but very late.
After World War II, the court continued to evolve. Truman's appointments included Fred Vinson, described by the source as a Truman crony and the weakest Chief Justice, whose death just before the Brown decision is called providential because he might not have secured a unanimous opinion. Quite a statement.
And Sherman Minton, another crony who had supported FDR's court-packing plan and received a failing grade from scholars. He dissented in early cases challenging Jim Crow. Not exactly stellar appointments.
But the legal battle against segregation was mounting, leading up to Brown v. Board of Education. These challenges weren't just about schools initially.
No, there were cases challenging restrictive covenants, like Shelley v. Kramer in 1948. A Missouri court had upheld them, ruling that judicial enforcement wasn't state action subject to the 14th Amendment. Thurgood Marshall and the NAACP were building their case cautiously, but George Vaughn, another lawyer, filed his appeal early, forcing Marshall to rush other cases forward, which the Supreme Court ultimately heard together. Strategy matters.
And challenges to segregated professional schools were crucial steps, like Sweat v. Painter in 1950, challenging the Texas Law School. The contrast between the 4 rooms for blacks and the massive building for whites was so stark, Marshall invited the justices to see it for themselves. Show, don't just tell.
And George McLaurin's case, also in 1950, challenging segregation in the University of Oklahoma Graduate School. Even though admitted he faced humiliating conditions like a hallway seat and a desk labeled colored, which NAACP lawyers rightly called badges of slavery.
Unbelievable.
These cases show that separate was inherently unequal even at the graduate level, chipping away at Plessy.
The lead case consolidated into Brown was actually Briggs v. Elliott from Clarendon County, South Carolina.
The black parents who brought that lawsuit showed incredible courage. The source details the heavy price almost every plaintiff paid. Fired from jobs, losing credit, foreclosed on their farms, even having a cow arrested for being off the property. Just brutal retaliation.
Judge Waring played a crucial role, urging Thurgood Marshall to directly attack segregation itself, not just argue for truly equal facilities, and ensure the case went before a 3-judge panel that included himself, the segregationist Judge Timmerman, and Judge John Parker, whose vote the case ultimately rested on. A brave judge.
Absolutely. After the landmark Brown I decision in 1954, striking down school segregation, the court heard arguments on how to implement it in Brown II in 1955, leading to the phrase, all deliberate speed.
Which turned out to mean?
Well, Thurgood Marshall's argument in Brown II was powerful, rebutting John W. Davis, the lead attorney for the segregationist states. Marshall argued that black Americans sought the same status as anybody else regardless of race.
He highlighted the absurdity of children playing together on integrated playgrounds but having to be separated in schools. and he deplored the determination of some to keep blacks as near that stage as possible. He famously urged the court, "Now is the time," that this court should make clear that is not what our Constitution stands for. A powerful plea.
Yeah. The dramatic exchange between Chief Justice Earl Warren and S. Emory Rogers, Davis's replacement, is telling. Rogers defiantly refused to say Clarendon County would honestly try to conform, leading to Warren flushing with anger and insisting Rogers leave it in the record, showing the depth of resistance.
The source notes that the justices, many politically experienced, made these decisions with a frank recognition of their political impact. They knew what they were doing.
The hostile reaction of Southern politicians who viewed all deliberate speed as an invitation to foot-dragging created the prospect of a second civil war of resistance. Chief Justice Warren, like Taney had generations earlier, was determined to assert federal authority, though for a completely different and righteous cause.
Eisenhower's response to Brown is also notable. The source points out he declined to publicly support the decision, saying it was difficult through law and through force to change a man's heart, creating a vacuum of leadership. That didn't help.
Not at all. This vacuum was filled by figures like Arkansas Governor Orville Faubus, who initially seemed moderate, but precipitated the Little Rock Central High crisis in 1957 by using the National Guard to block 9 black students from entering, despite the Eighth Circuit upholding the 10-year integration plan. Eisenhower was ultimately forced to send federal troops, a huge confrontation.
Moving into the later 20th century, the court continued to grapple with expanding notions of rights, often led by key justices like William Brennan, a real giant on the court.
Appointed by Eisenhower, Brennan became a legal powerhouse, described by the source as the most influential justice of the past half-century. His personal warmth combined with his legal brilliance made him remarkably effective.
His landmark opinions include Baker v. Carr, establishing the principle of one person, one vote, NYT v. Sullivan, creating a high bar for libel against public officials, Goldberg v. Kelly, establishing due process rights for welfare recipients, and Texas v. Johnson, protecting flag burning as expressive conduct. A huge body of work.
All of these, and many others, were guided by his bedrock commitment to human dignity. That was his driving force.
The Burger Court followed, with Warren Burger appointed as Chief Justice by Nixon, who viewed him as a law and order judge, notably someone who had criticized the Miranda decision, a different direction intended.
A major area of development during this time was the evolution of the right to privacy. Its roots can be traced to cases like Skinner v. Oklahoma in 1942, which recognized a fundamental right to procreate.
But it was fundamentally developed in Griswold v. Connecticut in 1965. The case challenged an 1879 Connecticut law banning the use of contraceptives, even by married couples, an old law.
A Planned Parenthood clinic opened, leading to the deliberate arrests of its director, Estelle Griswold, and Dr. Thomas Buxton, who, the source says, greeted her arrest with delight, having intentionally courted it to challenge the law after the court had previously refused to hear a direct challenge. They wanted the test case.
Justice Douglas's majority opinion in Griswold famously found a right to privacy lurking in the Bill of Rights, even though it's not explicitly mentioned. Where did he find it?
He described it as existing in the penumbras, formed by emanations from those guarantees, found in the Bill of Rights, arguing these implied rights gave the explicit ones life and substance. He pointed to prior cases, recognizing rights like freedom of association and parents' rights in education as examples of this implicit zone of privacy. Creative, maybe controversial.
This idea of a fundamental right to privacy paved the way for Roe v. Wade in 1973, the big one on abortion.
The case was brought by lawyers Linda Coffey and Sarah Weddington, challenging a Texas abortion law. They argued before a panel of elderly but liberal judges. Sarah Weddington's argument before the Supreme Court focused on her client, Jane Roe, arguing the woman is the victim of restrictive laws that lead to dangerous illegal abortions, and that abortion is a matter which is of such fundamental and basic concern to the woman involved that she should be allowed to make the choice, framing it around the woman's rights.
The source offers fascinating details about Justice Blackmun's process in writing the majority opinion, secluding himself, poring over history and medicine books, circulating drafts, a real scholar's approach.
Chief Justice Burger's visit to Blackmun led Blackmun to withdraw his draft and push for re-argument, despite the votes being mostly secured. And Justice Douglas sent an explosive memo, accusing colleagues of making a political gesture because it was an election year, and threatening to publish his statement. Internal drama.
After re-argument with new justices Powell and Rehnquist, Blackmun worked to craft an opinion that could hold the majority together, addressing concerns like Justice Stewart's point that fetuses were not considered persons under the Constitution, and structuring the decision around the trimester framework to satisfy others like Brennan and Berger, building consensus.
The final tally was 7-2, and the source reveals Chief Justice Berger's rather cynical maneuver. He deliberately stalled the opinion's release until after he swore in Richard Nixon for a second term because he didn't want Nixon to know he had joined the majority, showing how he manipulated the abortion decisions to serve his personal interests. Politics right up to the end.
Wow. The source also touches on other major rights debates of the era, like affirmative action in Regents of the University of California v. Bake in 1978.
Alan Bake, a white applicant, challenged the medical school's special admissions program that reserved spots for minority students. Archibald Cox, arguing for the university, contended that no racially blind method would admit many minority students. This led to sharp debate with justices like Stewart and Stevens over whether the program constituted an unconstitutional quota or a permissible goal to achieve diversity. A really tough question.
And the debate over sodomy laws in Bowers v. Hardwick in 1986, challenging a Georgia law criminalizing consensual homosexual acts.
Justice White's majority opinion and Chief Justice Berger's concurrence upheld the law, with Berger stating sodomy laws were firmly rooted in Judeo-Christian moral and ethical standards. Justice Powell, while concurring, was troubled by the potential sentence length, hinting at a possible Eighth Amendment issue with punishment severity, though he later expressed regret for his vote. He had second thoughts.
Finally, the source brings us to the Rehnquist court and the arrival of Justice Antonin Scalia. Reagan appointed Rehnquist as Chief Justice and Scalia to fill the vacancy. A new era begins.
Scalia is described as a partisan conservative, more combative than many predecessors. He argued strongly for a color-blonde interpretation of the Constitution and denied that it contained a basis for abortion rights. Yet, remarkably, he was confirmed by acclamation. Broad support initially.
The abortion issue returned in Webster v. Reproductive Health Services in 1989, challenging a Missouri law imposing restrictions on abortion access, Roe under direct fire.
Justice O'Connor's crucial opinion avoided a direct reconsideration of Roe, invoking judicial restraint to uphold the Missouri law without overruling the prior precedent, stating she would reconsider Roe carefully another time, kicking the can down the road, some said.
This prompted a scathing rebuke from Justice Scalia, who wrote a separate opinion attacking O'Connor for failing to overturn Roe outright, a move the source notes broke court norms and may have cost him a key future vote needed to overturn Roe, a very public fight.
And Justice Blackmun, the author of Roe, wrote a despairing dissent, stating, "I fear for the future, I fear for the integrity of and public esteem for this court. A chill wind blows."
Wow.
That sentiment, a fear for the future of rights and the court's role, really resonates through the end of the source material's historical survey.
It truly does. We've traveled from the attempts to codify law in the colonies through the intense debates of the Constitutional Convention, the struggle to establish the court's power under Marshall, the devastating impact of Dred Scott, the promise and betrayal of Reconstruction.
The rise of corporate power and the battle for worker rights, the fight for free speech during wartime and Red Scares, the dramatic shift of the New Deal court, and the ongoing complex battles over equality and privacy that continue to define the Constitution. It's quite a journey. The history laid out in this source material makes it undeniable. The Constitution isn't a relic, it's a battleground, constantly shaped by the people who interpret it and the struggles of those seeking to have their rights recognized. It is profoundly a living document.
And hopefully this deep dive has given you a curated shortcut to understanding some of the most critical moments, figures, and underlying tensions in that ongoing story.
What stands out when you look across this long history, as presented in this source, is the persistent dynamic of powerless outsiders, appealing to the powerful insiders on the Supreme Court.
Yeah, that's a great way to put it.
From enslaved individuals and abolitionists to workers, religious minorities, and those seeking equality or control over their own bodies, people have continually brought their most fundamental claims about liberty and dignity to this unelected body with immense power.
And how the different justices, shaped by their own views and the times they lived in, responded to those appeals has fundamentally altered the course of American history. It matters who sits on that court.
It leaves you to consider, what does it truly mean for a constitution to be living and changing, based on core values like the dignity of the individual when there are such deeply conflicting ideas about what those values mean and who they apply to?
Right.
It's a question that resonates just as strongly today as it did throughout the history we've explored.
Definitely something to keep thinking about.